The Hawaiʻi Supreme Court oversees licensed attorneys in our state and establishes rules governing duties, fairness, communication, truthfulness, and respect. The rules state that in Hawaii, a lawyer is a public citizen having special responsibility for the quality of justice. And there are consequences for attorneys who violate those rules. Join the discussion about the Hawaii rules of professional conduct. Tonight's live broadcast and live stream of insights on PBS Hawaii start now.
Aloha and welcome to Insights on PBS Hawaii. I'm Daryl Huff. The legal profession is largely self-governing. That's a quote from the Hawaii Rules of Professional Conduct, which are described as the rules of reason and provide a framework for the ethical practice of law. These rules guide attorneys licensed to practice law in Hawaii. They are adopted and enforced by the Hawaii Supreme Court and were last updated in 2013. The rules also provide a mechanism for disciplinary action when attorneys violate them. Our panel tonight includes the state's top law enforcement officer, a member of the UH Law School Administration, the attorney who heads the office that disciplines lawyers, and a representative from an advocacy group who takes care of lawyers who get in trouble. We'll look forward to your participation in tonight's show. You can email, call, or tweet your questions, and you'll find a live stream of this program at pbshawaii.org and the PBS Hawaii Facebook page. Now to our guests. Claire Connors is Hawaii's State Attorney General and as such is the top law enforcement officer in state government. Ronette Kawakami, a former public defender, is the Associate Dean for Student Services at the William S. Richardson School of Law at Manoa. Bradley Tam heads the Office of Disciplinary Counsel, which is overseen by the state Supreme Court. And Liam Deely is the Executive Director of the Attorney and Judges Assistance Program, which is also one of the Supreme Court, which helps attorneys who are having difficulties. And let me start with you, Liam. What kind of difficulties are we talking about, generally speaking? What kind of things come across your desk in terms of troubles that attorneys have?
It could be either they're having a drug or alcohol issue. It could also be a mental health problem. Basically anything that's going on in their life that's starting to affect how they're dealing with either their practice of law or, you know, their practice of law is fine, but other areas of their lives are starting to become unmanageable. So yeah, those are basically the overarching things. People are having some kind of either substance abuse problem or some kind of mental health issue that's going on.
And Bradley Tam, Office of Disciplinary Counsel, you are the Disciplinary Counsel. What are the broader categories of misconduct that you deal with most often?
Well, misconduct can run the entire gamut of professional behavior problems. Most common problem is where attorneys are failing to return phone calls from clients. That's probably the bread and butter of the business. And it can often be solved with a phone call from us. We call the attorney and say, hey, call your client. Then it runs to the opposite end of the spectrum, which is where the attorney is dipping into the client trust account and using money for his own purposes. When I went to law school, that was taught to us as the only unforgivable sin, which is misappropriation of client funds.
The only unforgivable sin?
Well, there's others, but
That's
you can work your way out of most of them. You touch clients' money, and that's bad.
It's supposed to be separated, right? I mean, there's very strict separation of, and every client's funds are separated from every other client's funds as well. Right?
Thou shalt not commingle your own property with that of your clients. This Rule 1.15 of Hawaii Rules of Professional Conduct.
Ronette Kawakami with UH Law School, generally speaking, what are the rules? I mean, you don't have to list them all, but what are the major categories where you think that attorneys and the public needs to understand that attorneys shouldn't be doing?
I think the major rules are, just no, like commingling, that's definitely a big one. But you need to be diligent. You need to work on your client's cases. You need to keep your communication open. Don't lie to the court. Don't lie to counsel. I think integrity and honesty is hugely important. That's what we teach at the law school as much as possible. Really drill that into students about their integrity and their reputation, because it's really important for your credibility in front of the court, credibility with your clients. That's, I think, one of the just the biggest thing is integrity.
You know, when you talk about diligence, though, that kind of surprises me, just because you'd think that, not necessarily be natural, but I mean, a typical lawyer must have a lot of
Right.
moving parts going on at any given time, and just not returning a phone call, I mean.
Right, absolutely. And one thing about being an attorney is it's not for the faint of heart. It's for people who have a really strong core, people who are, and I don't mean like, your abdominal muscles, I'm talking about just your inner core, that you have to be really strong, you have to be someone who can manage a lot of different moving parts, a lot of different things, answering your phones, doing your paperwork, making sure that you've done the research and things like that. So it is a lot of hard work. It's not easy work. It's also extremely stressful. So what happens is that, at some certain point, if you aren't finding other ways to release stress, like be a runner, have some kind of hobby, or do something that will relieve some of that stress, then you're starting to turn to alcohol, or starting to turn to drugs. Your family life might start disintegrating. So lawyers, as strong as they may be, are human. And like anyone else in any other profession, can fall victim to those kinds of distractions to sort of alleviate some of the stress.
Attorney General Kirk Connors, you've been a lawyer for a while and in various positions. What do you see as the thing that people should watch out for if they're working with an attorney?
Mm-hmm. Well, I think a lot of the things that have been said are right on point. I mean, the role of the attorney is, and it's right there in the beginning of the rules of professional conduct, to be a public citizen having a special relationship for the quality of justice, right? So the idea is that we are serving clients. We are participating in a process on behalf of people, institutions possibly, but at the end of the day, we're all looking for the same outcome. We are all looking to achieve justice. We're all looking to achieve an outcome that has integrity, that is not encumbered by things like conflicts or other problems. I've seen it in the government world when I was a prosecutor, having to be very certain that our prosecutions were unencumbered by conflicts. If we saw it in the grand jury process, one attorney trying to represent multiple interests, we had to be very clear that there wasn't going to be some problem, not just for the individuals who are being represented, but for the whole process and for the case itself. Same thing happens in the civil world as well. And
let me ask you, the conflict of interest issue, what's wrong with that? I mean, I think some people go, oh, this guy's a good lawyer, I want to have him as my lawyer, or this lady's a great lawyer, I want to have her as my lawyer, but then the lawyer says, oh, I have a conflict. And they can't even tell you what it is a lot of the times, right? So what are the issues around conflict of interest, and why is it so important?
it's important because, again, you can't be encumbered. Your interests or any interest you might have to another client cannot affect your ability to represent another client. So you have to be very clear in your ability to use your judgment, unencumbered by any other interests that might affect how you represent that person. And that's why they are so important as attorneys, as officers of the court, which we all are, to identify first ourselves. We as attorneys have to identify a situation and decide if this is something that I can do free of any kind of conflicting interests with yourself, with another client, or in that regard. And so we have that obligation first and foremost. And when we see a problem, then yes, usually it's a line in the sand. You cannot cross that line. And you don't want to get to the point where you think, you know, I can do it this time, or I think it's okay, because you can see that line start to shift, and it can become a slippery slope.
Oh, I see.
So we as attorneys really do need to be clear about our obligations and not go too deeply into the gray.
What happens when someone has a concern about that?
Well, first of all, when you're talking about conflicts of interest, one of the things that most people don't understand is that attorneys take in a tremendous amount of information from people, their clients, and that information is held in absolute confidence. Now, once I've spoken to you as a client, you've given me confidential information, I am forever bound for the rest of my life not to disclose that or use that information against you. Then later on, Renette comes up, she's got a problem. She talks to me, and it turns out that she's got a problem that Daryl had talked to me about earlier before. How can I separate the fact that I have your confidential information in my head, now she wants me to represent her, and that's running into a conflict. That's a train wreck which is unavoidable. And those types of circumstances are things that attorneys who are required to be competent, that's rule one, they're required to maintain their confidence. They're required to be diligent and to communicate. Those rules just basically say the attorney has to make a professional judgment that says, well, I can't go any further. You need to consult with somebody else. So, well, why can't you represent me? All I can say is I got a conflict. I can't say why, because that would be disclosing the information you related to me earlier in confidence.
You know, Renat Kakami, but so what he's describing is a little bit of the lack of transparency that people see when it comes to the legal profession.
Mm-hmm.
They you know, if you go, and we'll talk more about this later, exactly how you find out about attorneys and stuff, but you know, being quote unquote self-regulating or self-governing, what gives attorneys the right to do that as a profession as opposed to what other professions have to go through with, you know, strict state regulations and boards that are very public and so on? Why should attorneys be living with their own set of rules as opposed to what other people are doing?
So one thing about attorneys, or at least in our jurisdiction, is that and at the University of Hawaii, it's required that everyone take professional responsibility. So you can't graduate without professional responsibility. There's another test that they have to take, right?
You mean there's a test or a class?
It's a class,
Oh, okay.
right? It's a class that you have to pass like any other law school class as part of the requirements of graduation. There's also another class that they have to take after they actually pass the bar that has to do with professionalism, and they have to pass that also. So there's various different levels of testing when it comes to professional responsibility and following the rules of professional responsibility. The other thing is that, you know, we have to be licensed every year. It's not like, you know, you get licensed and that's it for the rest of your life. Every single year you have to prove that you have been behaving, that you weren't arrested for a DUI, or you didn't have an arrest for theft or something like that. So there's an ongoing yearly process. The other thing is that built into the rules is that we actually are supposed to tell on each other. So if I know that my partner is skimming funds from a client trust account, or if I'm aware that someone is forging documents or not doing something right, it is incumbent upon me to report your partner or whoever else that you know that is not doing what they're supposed to be doing. Otherwise, that's a violation on yourself also.
Dealey, when you, what would you say, you mentioned earlier that a lot of times it's personal problems or drug problems or some other problem that causes an attorney. But are there also just plain old-fashioned honesty issues or behavioral issues that just get in the way of doing a good job? And how do you help someone who just doesn't seem to get it?
As far as being professional, or?
Well, following the rules, I guess.
No, everyone that I talk to is actually very good at following the rules. I mean, it's just built into the profession. It's not only that you need the public to trust you that you're doing that, but, you know, a lot of things done between lawyers is done kind of like by giving you my word that I will do this when I get to court. And so if you start getting a reputation of somebody who can't keep their word, you're not going to be able to get a lot of business done in this town. So it's built into the structure. And what I usually see with my clients is that they're trying so hard to keep their law practice together and to keep their reputation intact that it starts to unravel in other ways. It starts to affect their home life or their life with their kids or, you know, outside pursuits. Because it's so important to be able to keep that reputation intact that it's usually the really last thing that starts to fray at the edges, is that when I'm worried that what I'm doing might start to tarnish my reputation among my colleagues, it could be the last final wake-up call for them to actually reach out for help.
Let me say first and foremost that the vast majority of attorneys in Hawaii are really good, honest people. There are people that have stresses due to personal problems, health reasons, age, substance problems and things like that. That happens, and we try and work with those people to help them overcome those burdens. Very, very, very small percentage of lawyers in Hawaii are the kind of people that really need our office to focus on and discipline. The ODC is here to, number one, protect the public, Number 2, maintain the integrity of the courts. And third, to enhance the profession. We don't represent individual people. The attorney discipline system in Hawaii, we are self-funded. We are not self-regulated. The regulation comes down from the Hawaii Supreme Court, and they make all the decisions when it comes to discipline. ODC and the disciplinary board only make recommendations.
Don't we fund you with our dues every year?
Yeah.
Certainly do.
So
Average lawyer pays $550 a year. Half of that goes to the disciplinary
But there's
system.
also the other function that the ODC performs, and it sort of tees off of what Renette said earlier, was that we can seek opinions from ODC, which is helpful. So if we are in a situation where, as officers of the court, we are obligated to bring misconduct to light. We can't sit back and say, they're not supposed to be doing that, again, because of the integrity of the process, but because of the way we govern. So ODC has the ability to issue opinions if you are not sure if this is something that's ethical, if you're not sure that this is something you can do, you can seek an opinion to answer some of those questions.
We have a hotline procedure where the attorney, a Hawaii licensed attorney, can seek ODC advice as to their prospective conduct. Their conduct, not the conduct of somebody else. If you're calling about somebody else, you have a duty to report misconduct. But if you are looking to see whether your anticipated conduct is ethical or not, an ODC lawyer will talk to you.
Is that usually in the form of a hypothetical, though, as opposed to
We
Joe
don't
Blow
do
as-
hypotheticals. They call us up, they tell us what their situation is, and within the narrow confines of what they've called us on, we'll then advise them on what rules they need to review. We're not acting as their attorneys, but we'll point out what rules they need to review to see, to bind their conduct with. I did want to get back to your question about transparency and why we don't appear as a transparent a profession as some of the others do. It's primarily because of attorney-client privilege. This is one of the most sacred privileges that exist in the law, that we want to encourage individual citizens and persons to communicate with their lawyers and communicate openly with them. So attorneys have to hold so much in confidence. There is a need to keep this system tightly bound. We can't be as public as the other professions can be.
In your experience, Clark Connors, what do you think trips up most lawyers? Okay, I might be doing the same thing.
Just a minute.
It's that time of year, I think.
What trips up most attorneys?
And let me just ask this. You've been head-to-head with some of the tougher defense attorneys, and Renette, you also have been head-to-head with some of the tougher prosecutors and so on. I mean, I think it's hard for people to imagine that these people who are fighting it out over life and death issues, who are fighting it out over huge amounts of money, are doing so with the purity of an ethical heart beyond anyone else. I mean, is it really that clean all the time, or is there a lot of sharp elbows done in an ethical way? I mean, I'm just sort of...
And I think it's actually different. When you're in the context as a criminal attorney, you, especially as a prosecutor, you have a higher standard that you are held to. You have disclosure obligations that are of a higher level incumbent on you than in the civil.
Can you be more specific about how that works? Because frankly, we've had prosecutors being scrutinized pretty heavily, and transparent they weren't. But I mean, without speaking specifically to that, what do you mean? What kind of disclosure do you have to make as a prosecutor?
So in the criminal context, you hold all the cards, right? You've had the ability to do the investigation. It's generally secret. In the federal level, you have Rule 6E, which is the grand jury secrecy rule. So things, unless people who are part of the grand jury process as witnesses talk about it, it's entirely secret. So you know all the evidence. You have all the evidence at your disposal, and then you make the charging decisions. When that charge comes out through the grand jury process or some kind of information, some kind of charging document, then it's incumbent for, again, justice to be served, for the prosecutors to tell the defense everything that they know about the evidence that they have, determining in their mind why this person is guilty and why their civil liberty is at issue in this particular matter. Those obligations are not at that level in the civil world, and there is a lot of discussion, a lot of litigation surrounding what should be disclosed, what should be given to attorneys, and so it's actually more of a war zone in the civil world, to kind of look off the metaphor that you used, is that you are fighting a lot more in the civil realm, because it's not as though, hey, let's put everything on the table and let's really just go to trial and what all the evidence is. There's a lot back and forth. And I think that's what trips up attorneys. They can, at least in the civil world, they really can try to, well, not
Hide
try
the ball.
to. Yeah, hiding the ball is certainly an advantage. I mean, you know, you're not supposed to do that. The discovery rules, even for the civil context, say you're not supposed to do
Really?
that. But there's a lot of motions that are filed about what should be disclosed and to what extent. And
Let me ask, Renette, in your experience, I mean, have you had prosecutors always be so straightforward with you about your cases?
Not all the time. Not all the time.
And then what happens?
Well, you would hope that they would be. I think that there's a lot of, one thing I have to say about the criminal defense and the prosecuting world is that for the most part, everyone gets along. It's the same people you have to see every day. You have the cases are all the same. Well, you know, the players are all mostly the same. And I think there are very few people that you don't get along with. That doesn't mean you don't fight hard in court. That's one thing I liked about being a public defender is that, and this is a little bit of what your answer to the question you asked earlier, is that you don't have to really think about anything else but representing your client, because you're a public defender. You're going to get paid. You don't have to think about, you know, my fees. Do I need to, you know, do this or do that because it's going to cost more money? It's going to cost more money for my client. You are just thinking about the law and representing your client. So you don't have to worry about overhead and all those other things that private attorneys do have to think about.
So when you found yourself, what was your remedy if you found that you didn't think a prosecutor was a prosecutor withholding something or playing games with you?
Well, in the state side, it's Rule 16, and it's a discovery motion. And basically, if someone is not giving you what you're supposed to have, it's a motion to dismiss the charges.
So
and
you
there
rely
have
on the
been times-
judge, right?
Right. So you would asking the judge to dismiss the charges because the prosecutor hasn't given you what they're supposed to, or they're hiding the ball on something, which is, you know, constitutionally we are allowed that. Whereas you don't have the same kind of constitutional teeth on the civil side.
Okay, I got some questions from viewers that are coming in. I'm pleased. So this one I think is primarily for Bradley Tam as Officer of Disciplinary Counsel. How many lawyers are disciplined each year? How many lawyers are in Hawaii? So we don't need all the numbers, but ballpark? I know you've actually got actual numbers.
Sorry.
It's okay. No, I think people want to know. So
Okay, well, presently, members of the bar is about 8,000 lawyers.
really?
Yes. That's
Wow.
not as bad as it was in San Diego.
Bad meaning too many or too few?
Of the 8,000 members of the bar, 5,000 are on active status, are government lawyers or judges. 3,100 are inactive. Of the 4,000 that are active non-government or judges, about 1,317 are sole practitioners. And that's pretty much a breakdown of.
So how many get disciplined? Like how many disciplinary cases did you get this year or
Well,
last year?
I'll tell you, in the last 12 months, I received 526 complaints.
And those are 526 different attorneys, or are those sometimes?
Those
involve
are,
multiple?
some attorneys get multiple complaints against them. Everyone who practices law and deals with the public is going to get a complaint filed against them. If you do a real good job, the person on the other side is going to complain against you because you were overzealous. If you don't do a real good job for your client, he's going to complain against you because he saw you talking to the other side, and obviously you're in collusion. There's some unhappy people out there.
Let me just interrupt you for a second. Claire, in your experience, particularly on the civil side and the prosecutor side, I mean, did you have people complain about you?
I'd like to say that it's because of what Bradley said. I was doing my job. I'd get motions for professional misconduct filed because we'd have a conviction, and I got sued by defendants who I was able to secure a conviction against. So I say I've been targeted by that kind of conduct myself, but I've never had an ODC complaint filed against me, which is different.
That you know of.
That's different.
I was going to say, are you sure?
Okay, maybe I have. All right. Who knows? I've never had an action officially adjudicated.
Ronnie, what about you? What's your experience with that?
I'm sorry.
With ODC, I mean.
Oh no, I think public defenders are easy targets. I think that oftentimes, and we work very hard, by the way. I think oftentimes, clients are disgruntled. They have a lot of time on their hands, especially after if if and when they are convicted, they may have a lot of time in their hands, and they do file complaints in the ODC, and oftentimes the majority of the time they are just tossed out because they're without merit.
Yeah, 15 to 20% of the complaints we receive are against either the prosecutors or the defense, or both.
So the criminal side, well, that's still, there's a considerable left for the civil side.
Yeah, I would say that the civil complaints are more aggressive. The criminal complaints, for the most part, somebody sitting in Halava or OCCC,
It's pretty easy.
they have nothing else to do but sit there and write the complaint. And if they can make out a good case, maybe they can have their conviction looked at again. So I don't short them for it. Every complaint that we receive, we look at it carefully. About 25% of them, though, are meritless and they get dismissed. And a lot of times, the attorneys who are complained against will never know that the complaint came through our system.
Do folks get are there a lot of complaints about billing?
Yes.
Yeah, because I got a caller says, person retained an attorney and several years later called the attorney and got a bill. How can attorneys charge you if they have not disclosed they're going to charge you? What are the rules around charging, and how do you know what you're going to pay and stuff like that? Claire, I mean, you've been...
I don't know, the one thing that comes to mind is you might have retained a trust and estates attorney, for example, and they did a trust for you, and then a couple of years later you call up and say, you know, I have a question about the trust, or there's something that reopens that representation. But that situation seems a little unusual, because usually you think the attorney, especially if it's been a few years, would say, by the way, I'll be charging you this fee, or our agreement that we had years ago applies now, or there'd be some kind of conversation like that. I would think is just a professional courtesy.
What do you teach lawyers in the law school about how they should bill? I mean, is there any standards or standards of practice around billing that people should be aware of?
So that's a good question that I don't know the answer to.
Oh.
That's because that's not what I teach.
Oh, okay.
And so for my side of it is more just sort of, you know, professionalism and behavior, and how you treat each other, how you treat your clients, how you treat people.
The law firms will teach you how to bill.
Right,
They're
that's
the
correct.
ones who tell you how to bill.
Oh, is that, do you find that the people that end up, you're helping a lot of them, we mentioned financial mixing and so on. Mm-hmm. Is it financial problems end up often being one of the first things that goes wrong with an attorney?
Yeah, so for most lawyers, they're solo practitioners. And so you learn how to be a lawyer and think like a lawyer and write like a lawyer in law school, but they don't give you a class on being a small business owner. So now you have to figure out the rent, you know, somebody has to buy the staples, you know, just the little things that you don't know about. And so a lot of times people are trying to generate enough income, and you can never really plan out long enough, like how am I going to be able to keep this stream of income coming in? And so that adds a whole nother layer of stress to a lot of the attorneys. How am I gonna be able to pay for all this? And then it gets compounded because, you know, they get married, they have kids, and it's just all these other concerns about the finances. It's like it's an ever-present thing. And so if you are a solo practitioner, that is kind of like, okay, you know, you're always thinking about the next thing, and it's like, you know, how am I going to do this? How am I going to keep this going?
Brother Ted, how many of the complaints that you get, how much involves financial issues, would you say? Ballpark's okay.
I'd say half of the complaints involve some kind of dispute which relates to money. But client trust account mismanagement is the most significant leading factor in disciplinary cases which end up going formal, not disposed of through other minor diversionary type programs.
So can you explain how someone might realize that this has happened, or how does it come to people's attention if someone does
The
it?
client or the lawyer?
Either way.
Well, if the lawyer writes a rubber check on a client trust account, he or she should learn about it promptly from their bank. What many of them don't realize is the bank also writes a letter to the Office of Disciplinary Counsel. This is why in Hawaii, there's only 9 banks which are authorized to hold attorney-client trust funds, and they must subscribe to a system called IOLTA, which is interest on lawyers' trust accounts. And they sign a contract with the Supreme Court that says that they will report any overages to the ODC. And that instantaneously upon receipt of that report, we commence formal investigations, and unless there's a darn good reason for the overdraft, that will result in some kind of formal disciplinary process.
One thing I'd add to going, just keying off of this idea that there are a lot of different things that lawyers confront when they get out into the practice of law. That's why we have a bar association too, and that's why we as attorneys participate in things like continuing legal education. So there was some discussion about what you have to do, what kind of ethical classes you have to, or ethics classes you have to take in law school, and then to become a member of the bar, but then there's continuing legal education that we all have to do, and ethics requirements. You're required to do an hour of ethics. We all know our ethics requirement. But we as a bar association come up with the types of classes and curriculum that we think might fit the needs of our members. And I think that might be solo practitioner lawyers. I mean, that's the kind of thing, the types of needs that lawyers might have when they get out to the practice could be addressed by the Bar Association with different kinds of classes. And
yeah, and they
things
do,
like
and
that.
mostly from the side that I'm dealing with, it's just, you know, the personal stress that they're going on that could lead to, you know, a need for some kind of assistance, personal, outside of obviously what they learn from the Bar Association.
So what Attorney General Connors is talking about is mandatory legal education, continuing legal education. It's mandatory, so we have to take it every so many years. You have to have so many credits. But the classes themselves are vetted. They are rigorously vetted by a committee, and you have to pass their vetting in order to even offer it, in order to get those credits. And they do take really close take a really close look at those classes.
We're
We
getting
as members of the bar get to decide
Correct.
what kinds of classes
Right.
too would be helpful to our members.
So from let's sort of turn things around to the consumer point of view, okay? Because one person writes, I was involved in 2 legal actions that extended into decades. My attorneys were not honest. Who should he complain to? Why does the case take so long? I'm not sure if the why does the case take so long is more about the court cases, which can take a really long time. And you know, what should someone do, and what should someone look for in the behavior of their attorney that might be something they should complain to?
Well, first of all, there's a lot of advantage when you're seeking medical advice to get a second opinion. There's nothing to stop a person from getting a second opinion from another lawyer. And that's usually a good place to go if you think something's amiss, but you don't have a real handle on what's going wrong with your case. Get a second opinion. If you believe that you have been cheated, or if the lawyer has done something unethical or dishonest, and by the way, lawyers are not allowed to lie. They can not say something, but they can't tell lies. It's
I mean,
dishonest.
it's so
that's
funny
good.
because what's the Shakespearean anyway?
Shakespeare was a
Was it
client.
Mark Twain? Was it?
There have been many, I'm sure.
But no, the reason why we get 500 complaints a year is because people will write to us and tell us what they think their lawyer did, which was not right. And I personally review every single complaint that comes into the office. And if the complainant gives me facts, then I can investigate it. If all they call up is just, my attorney was mean to me and my attorney did a lousy job, those are conclusory allegations. I can't do much with it.
Go ahead.
So one thing I want to go back to actually about the on the criminal side of ODC is that it's important to remember, though, you know, even though a lot of the cases do get dismissed, those that aren't dismissed, and when a client has been wronged by a criminal defense attorney and that attorney didn't do a good job, those are grounds for reversal and for the court to take another look at the case. And there are people who are, you know, factually innocent, and it's important that you remember that those cases need to come forward. So.
Another question becomes, when the Office of Disciplinary Counsel finds someone has misbehaved, will they or any other organization work to seek restitution for a client who's been harmed? Is there a way to get back whatever harm was done by an attorney who's...
That's a question for me. It's under Rule 2.3 of the Rules of the Supreme Court of Hawaii, that one of the remedies that we can ask for in a formal disciplinary proceeding is restitution. But the complainant is not our client. We're here to protect the public, not to protect an individual client. We don't pursue these cases in order to make the client whole. The client can go hire an attorney and sue for malpractice or breach of contract or any of the other civil remedies that are available. But generally you see restitution in cases where the attorney misappropriated funds out of the client trust account. Client settled the case for $12,000, that $12,000 disappeared. We'll seek disbarment because funds have been misappropriated, and we'll ask the Supreme Court to order restitution, that before the attorney can get his license back 5 years down the road, they're going to have to pay the client back. But restitution, though, doesn't necessarily come with interest. It isn't a big win. It's just a side issue that we may be able to get ordered.
You know,
Isn't there also a lawyer's fund? too?
There is also a lawyer's fund for client protection, where if an attorney has acted dishonestly, they can apply to the lawyer's fund for client protection for restitution. The fund is completely funded by the bar. It's kind of like our own Federal Deposit Insurance Corporation, like an FDIC type thing for lawyers. It does not reimburse the client for funds that were negligently, you didn't win your case. You can't file lawyer's fund there. But if the lawyer stole your money, that's what the lawyer's fund is there for.
there's another, this kind of comes close to home for the Attorney General because this was a case that you were involved in, but I should ask a question to honor the caller. The Maui County Corporation Council was arrested but not charged by the state attorney. There's a lot of coverage of this. Is it possible for the Bar Association to still punish him? Is that something that, what would happen? So you folks decided not to charge this fellow for whatever reason, and then, but do you then, would you or somebody else be responsible for turning him into ODC? I mean, because I think Mr. Tam mentioned that you're not allowed to break the law if you're a lawyer.
Mm-hmm. Right, and so I think there's the first part of that, which is our office did review it. We did look at all the evidence that was presented to us. We did do an analysis to whether or not it comported with any potential violations, and we made the determination it didn't. And that was made public. And then from there were a couple things that could happen. I think the mayor issued a statement, and there was a decision that he should step down from the position, which he did. Our office wasn't involved in that at all. In terms of whether to prosecute someone and whether someone's prosecuted is a different question from whether or not there was an ethical violation committed by that person in the course of their legal representation.
I could also add to that the rules of the Supreme Court says that Office of Disciplinary Counsel shall investigate all matters brought to its attention by complaint or otherwise. Otherwise means we do read the paper, we watch the news on TV. If we see unethical conduct or what might be unethical conduct, we can open up a case ourselves. I cannot speak to any individual case. Obviously, they're all confidential. But things go on in the news, they become public knowledge.
But in your experience, because before you were disciplinary counsel, you were on the board of Disciplinary Review.
Disciplinary board.
Disciplinary board. Did you ever see a case that was literally generated out of a news report that someone turned someone in?
I've seen cases where ODC initiated the complaint. They learned about it. I saw one case where an ODC staffer was walking on the street and overheard a couple of people talking in front of him. That does happen. It's the majority of our complaints are from the public. But there are a few, half a dozen or so, that are sitting there that we picked up through other avenues.
And correct me if I'm wrong, but when we reapply for our license every year, don't we have to disclose that we've been arrested? If we've been arrested. So the disclosure is on our application.
Is that the threshold, though, for taking someone off the bar, is if they've been arrested or indicted? I mean, is that, so you could be arrested and indicted and still practice as an attorney?
It's not automatic.
I'm not certain, but I think if you've been arrested, you're not required to report it. I think if you've been convicted of something other than traffic infractions or petty misdemeanors. If it's a misdemeanor or a felony, you're required to report it. If you've been the subject of a disciplinary proceeding in another jurisdiction, you're required to report it. Not only are you required to do it on your annual bar registration, but carefully in Rule 17, it says you're supposed to notify the HSBA within 30 days of that event.
Let me ask, before someone hires an attorney, and what should they do? You mentioned the second opinion. Where do they go to check and see if this attorney has a clean record? Is there an easy way to check? You and I were talking about this earlier, and it wasn't that easy, but what can you find out about a lawyer in advance of hiring them?
Well, you can go to the Hawaii State Bar Association website where you can go to the directory and you can click on someone's name and it'll tell you whether their license is active or inactive. If inactive, is it voluntary, involuntary? So if it's involuntary, that means there's some kind of disciplinary proceeding. If it was voluntary, that means they might be just taking a break or they might be retired. So
that's something they should check.
Yeah, absolutely.
Just routinely check.
Absolutely.
Have you seen lawyers who continue to practice after they were suspended? You ever seen that happen?
Have I seen that? No.
Yeah.
No. I mean, Bradley knows all that more than I do.
And if the ODC learns that an attorney's been suspended for any reason, be it administrative for failure to complete their legal education, or if they've been suspended by order of the Supreme Court, we find out they're still practicing law, this can be a very aggressive prosecution, and we will seek disbarment.
Are they required to tell all their clients if that happens?
Yes, Rule 2.16 of the Rules of the Supreme Court of Hawaii, disbarred and suspended attorneys are required to notify their clients within a certain period of time, a short period of time, I think it's 30 days, of a disciplinary suspension. Don't have the exact same rule on administrative suspensions because those are done by the bar, and they can be reinstated by simply completing the CLE or paying up their dues.
Let me ask Attorney General Claire Connors, how should people evaluate it besides just going on a website and checking it out? If you were advising somebody about, which attorney should I take, I'm sure you would tell them this is something you have to work out for yourself, but what should people be looking for? What kind of questions should they ask?
Well, this is from now my private sector
Right,
background.
exactly. Yeah.
I think, one, you meet with multiple attorneys, as Bradley said. I think you go in and you have that initial consultation, which is generally not charged.
But should you ask, like before you see somebody, will you charge me if we have an initial consultation?
Yes, always. You always want to be clear about what the, and attorneys have the obligation to be clear about that too. We have to be very clear in the payment structures that we set up and the fee agreements that we enter into. But I do think that in terms of finding the right fit, because it is finding the right fit, this is a person who's going to, in the civil world, take on your burdens, right? You're going to say, you've had this terrible thing happen to you. I will represent you and I will be the one who takes this off your shoulders and moves through the court system and seeks justice on your behalf. So it needs to be a good relationship that you feel comfortable with, that you think the attorneys inspire confidence in you. So that might not happen with the first one or two or maybe even 3 attorneys that you meet with. But there will be questions that you want to ask about how many times the attorney has had this kind of case, about what they can tell you after the attorney's initial review of your case, see how much due diligence they've put into their initial intake. So it's the beginning of a relationship. So in any kind of relationship, you want to do your due diligence, aside from checking Yelp and checking whatever other publicly available sources of information there are. You really want to have a good gut sense about a person you're about to enter into this relationship with.
If I could add one thing, when you're looking for an attorney, beware of the lawyer who tells you that you've got an absolute slam dunk case and there's no way you can lose.
Yeah.
That's a salesman.
Yeah.
Right.
And you know what happens when you deal with salesmen. When I hire a lawyer, and there's been times where I've needed to hire a lawyer, I want a lawyer who's going to be honest with me, going to tell me what my risks and problems are. Not going to necessarily tell me what I want to hear, but he's going to tell me what really is going on. That's what you're looking for.
What about your own experience? What do you say if someone asks you, what should I look for?
So when people call me for a referral, I give them 3 names. And I tell them, just go call every single one of them and ask for an interview and talk to them. Find out, you really want to be comfortable with that person. Tell them it has to be a really good fit. You don't have to stay with the names that I give. I tell them that you don't have to stay with the names that I give you. You can ask them for further referrals if you don't like them, or it just doesn't seem right, or the cost is too high. Or they can always call me back. But I think fit is the most important, that they have to feel comfortable with that person. That person's going to, seems honest to them and is straightforward.
I think you can contact the HSBA too if you give them a general idea of what your case is about and what it entails. They'll give you 3 names, and if you don't like any of them, you can call back and they'll give you 3 more. So that's usually a kind of a good place to start, where you're going to get like a non-biased place to start checking into lawyers.
I'm getting a few questions. This is, I think, the 3rd or 4th question I've gotten about money, and I think that there's this very intimidating thing as soon as. And I've been in conversations with people who go, I don't want to hire an attorney. I can't afford an attorney. It's like automatic, right? And you try and resolve your problems without the help of an attorney, even if people are threatening to go to court.
Pay for a Volkswagen, don't expect a Cadillac.
Pay for what you get, huh? No.
Well, is there? Go ahead. I'm sorry. So, well, let me just read this question, and you guys can all pitch in. What other avenues does a citizen have if the lawyer fees are going to wipe him out if he loses? Any advice for that kind of person who's so afraid to hire a lawyer that? And again, if you lose, you're going to have to pay the lawyer, right? Mostly.
Right. So there's 2 scenarios, right? If it's a plaintiff's case, usually that's a contingency fee arrangement. So you actually are not going to be, if you've been injured by the negligence of someone else, you are usually not going to be out of pocket anything. You've suffered enough. You are broken in the eyes of the law, and now you need to be fixed. And the way those relationships work is that the attorney will front all the costs. The attorney will only get paid if the attorney wins, and that's the structure there. And I have, when I've looked at non-plaintiff type cases and taken someone on a retainer, you definitely want to be honest with them about what the fees possibly could amount to and whether or not it's worth to take this through litigation. Litigation is one option. There are a lot of other options. You can do mediation. Arbitration is also an option. It does require an attorney and does require fees, but there are other ways of resolving conflicts. There's also pro bono that's available if someone really cannot afford it. We as attorneys are supposed to do at least 40 hours of pro bono work, and many of us do. We staff the Access to Justice Center. We provide pro bono services just to people who need advice, and we don't feel like it's something we can charge someone with. We don't want to necessarily enter into an attorney-client relationship with that person, so you very much at the outset need to be clear, I am not representing you, because once you establish that attorney-client relationship, a lot of obligations fall on your shoulders.
Give me the name of that organization again, because I think people, you mentioned people, you're staffing. What?
The Access to Justice Center was something that was set up through the judiciary, I believe, and it gets staffed by attorneys in the community. So our law firm used to go in there and spend a couple hours just providing advice to people. Anything from, I'd like to file a TRO, a temporary restraining order. What do I do? And we would sit down there with them and help them fill out the TRO. We'd help them look at maybe a condo agreement or something that might be going into a small claims type situation. We would help them navigate the system, and we'd be actually situated at district court where people were coming in with an issue and they needed help. And that's been a very good initiative, because it is allowing people to come to the court system and have some legal advice and some available to them.
You've also got Volunteer Legal Services of Hawaii, which does excellent work, and a lot of lawyers volunteer in there. I've spent many hours in that place. Legal Aid Society of Hawaii is another one that's open. There's numerous.
So how poor do you have to be to get those kind of services? I mean, is it?
So at the Public Defender's Office, there's a assessment that's done. So you list all your assets, you list all your
for a public
debts.
defender, you're
public
talking about,
defenders,
for a
and
criminal
they
case,
take a look at what outweighs what. Sometimes you can be someone who has a home, you might have a car, but you still would qualify for public defender assistance, because
you might be a former police chief.
You might be a former police chief. Because the cost of criminal defense, especially a full jury trial, is really pretty prohibitive for most people. It's going to be a lot of money. It's usually cash up front. So a lot of people who may seem like they're middle class who can't afford an attorney will qualify for the public defender's office.
I'm also going to plug UH here for a bit too, because they have clinic programs. So
that's correct.
Again, going back to this idea that we self-govern, that we want to teach our attorneys how to be good attorneys through sort of apprenticeship roles. So, for example, I worked with UH in the Small Business and Entrepreneurship Clinic, and we would run a clinic session where people who had a small business idea or who wanted to set up an LLC or who wanted to do something in the business realm could come to this clinic. We had hours and could get advice from students who were under the supervision of practicing attorneys, and then they could also possibly be retained by these law students who were under the supervision of licensed attorneys and get legal services for free. And that's an important thing that the university does in concert with practicing attorneys in the community.
And that's a great plug, because we are going to have a new clinical building that's going to open up in a few months, and the clinical building will specifically hold those kinds of programs, defense clinic, prosecution clinic, elder law clinic. I think we're going to have a veterans clinic. We have an immigration law clinic.
Do you already have some of those things?
Yes, we already have them, but they're not housed in that building, which is new, and it should be open soon.
So if somebody gets really confused about what they should do, they could call the law school?
Yeah, they can.
They call you?
Okay, call me. That's fine. I'll take the hit. But don't call me for this. But when we talk about pro bono, I actually keep my license active specifically because I sometimes do pro bono for cases.
This is an interesting question that I'll throw out because it kind of goes to the people's sort of suspicions. Does Hawaii Bar Association have standards governing TV advertising for lawyers?
They do.
Is there rules? I mean, it used to be they weren't allowed to advertise,
Yes, there are.
except on the back of the yellow pages or
7.2 and
something.
7.3 are the rules that pertain to advertising. Bottom line is, it can't be misleading. You can't say that you're better than another lawyer. You can't say that you specialize in a particular area of work without certain disclaimers on it. But this is America. It's the land of free enterprise, and for the last 50 years or so, lawyers have been allowed to advertise. I do remember when they couldn't.
Right.
That's why so many lawyers ran for political office. It's the way they advertised.
Are there still problems? I know that there were problems with attorneys that would take, for example, drugs in return for pay or stuff, a house. Is that still okay, or not drugs? I mean, not illegal drugs, but I mean, in terms of
In kind.
in kind, or signing over a house or something like that. Is that okay?
I knew a lawyer who was in an old folks home with my father, and he told me that after World War II, when he first started practicing law, he accepted chickens and blankets to represent clients. That's the barter system. It is perfectly legal. If you receive an 8-ball of heroin in exchange for fixing somebody's traffic ticket, you're going to prison and you're going to lose your license to practice law. So it must be legal exchange.
Sure. Who can forget the iconic scene in To Kill a Mockingbird when
right, exactly.
Atticus Finch is accepting from the farmer, I think, some sack of potatoes or some kind of like that. So it's iconic.
And I'm going to throw out one other thing. When in my experience, I have seen cases where people feel like the judge and the lawyer are too close. I covered one with a soap opera star that ultimately the Supreme Court actually threw out the case because did feel that there was too much of a relationship between. How about that kind of issue? How does a client bring that up? Who should bring that up when the judge who's supposed to protect you doesn't seem to be protecting you?
Well, Hawaii is one of the smallest, jurisdictions around. Everyone knows everyone.
In fact, I have a question from someone from Hilo saying, I can't even get a lawyer in Hilo because everybody's conflicted out.
Right, and that happens. I don't know what happens when you bring somebody in from the neighbor islands, but because we're such a small place, I think that the important thing is everyone disclose possible conflicts, and it's always best to avoid the appearance of impropriety. The judge can be challenged. You can say that someone can say that I'm going to ask that you recuse yourself because I think that you can't be fair and impartial because you know the opposition's attorney, or you can always file those motions. Now, whether or not they get granted is another thing. I think for the most part, judges try to be fair, and they do, and their rule is they have to avoid the appearance even of impropriety. So there are other judges that can step in.
They have their own codes of conduct,
Right.
judicial codes of
That's
conduct
correct.
that they have to.
And they
abide
can
by.
bring a judge in from the neighbor island.
Yep, and
Yeah.
they-
But just because the lawyers know each other and the lawyers know the judge doesn't necessarily mean that there's a problem there.
Correct.
I came from a small area of law. I practiced bankruptcy for many years. We only got one judge. I'm in bankruptcy court every day. We are on a first name basis, basically, although his first name is Judge. But just because we know each other doesn't mean that he isn't going to rule against me 50% of the time. He's going to call the shots the way the law says because we're professionals for the most part. Now, there is the rare case where the bounds of propriety have been overstepped. I saw it a lot more in California than I do here in Hawaii.
Okay, well, you know what, gang? The hour is over. Thank you so much. Thank you to our audience.
We'll send you an invoice now.
Oh, God. Oh, God. This is expensive already. Mahalo to all of you for joining us tonight. And we thank our guests, Claire Connors, State Attorney General, Bradley Tam, Chief Disciplinary Counsel, Ronette Kawakami, Associate Dean at the UH Law School, and Liam Deely, Executive Director of the Attorney and Judges Assistance Program. Thank you, all of you. Next week on Insights, failing the road tests. Why does Hawaii always score poorly in surveys about roads and highways? It's because they're junk. Join us. I'm Daryl Huff for Insights on PBS Hawaii. Ahui ho.